We'll share them. Last seat. We're live in 15 seconds, please. 13, 12, 11, 10, 9, 8, 7, 8, 7. Solicitor. Okay, wait a minute. Honorable Minister of Justice and Attorney General of the Federation, the Chairman, Presidential Communication Team, our freshly minted Solicitor General and Permanent Secretary, Ministry of Justice, DGNDLEH, Brigadier General Buba Marwa, retired, other guests on the Minister's entourage, guests from the Ministry of Justice, our stakeholders, both here and online. Good morning. In our series of briefings by key stakeholders in this Nigerian project, this morning we have the Attorney General and the Minister of Justice. Undoubtedly, the administration of President Muhammadu Buhari has recorded outstanding feats and achieved remarkable successes in the key area of justice reform and the fight against corruption. Some of these reforms have led to an improvement in the justice dispensation and efficiency in the nation's jurisprudence. In the course of the implementation of some of these reforms, the federal government has made major strides in ensuring diligent prosecution of cases while securing convictions in key corruption cases that had been pending in Nigeria's law courts. This morning, we have the minister with us, and he's ready to update us on the strides being made by his office to ensure effective dispensation of justice and the plans being put in place to institute these justice reforms. As usual, the Honorable Minister will come here and speak to us for about 30 minutes, after which we'll take questions from media men here and members of the public who are watching us online. On this note, I would like to invite the Honorable Minister of Justice and Attorney General of the Federation, Abubakar Malami, Senior Advocate of Nigeria. Oh, sorry. Sorry. It's like, sir, you were expecting me to say shoes. Sorry, sir. Abubakar Malami, Senior Advocate of Nigeria, to talk to us. Honorable Minister, sir.
Distinguished members of the press, the Chairman, Nigeria Law Reform Commission, Professor Jume Audi, the Chairman and Chief Executive, NDLEA, Brigadier General Buba Marwa, retired, DG Niles, Professor Mohammed Tawfiq Laden, the DG Legal Aid Council, Aliyu Bagudo Abubakar, DG Copyright Commission, Dr. John Asen, my colleague, partner, and indeed the administrative head, Federal Ministry of Justice, and the person of Mrs. Abba, the Permanent Secretary and Solicitor General, and the Federal Ministry of Justice, the directors in the respective parastatals under the supervision and oversight of the Federal Ministry of Justice here present, the principal officers in the service of the federal government here present, with particular regard, in this case, to Mr. Garba Shehu, and indeed Femi Adeshina, that are anchoring and indeed facilitating this engagement this morning. Ladies and gentlemen, good morning. As you are rightly aware, President Muhammadu Buhari-led administration has recorded outstanding successes and indeed achieved remarkable feats in the key areas of justice reforms, the fight against corruption, and good governance that are rooted in judicial reforms, which in effect translated to improvement in justice dispensation and efficiency of the Nigerian jurisprudence. In the course of implementation of these major reforms, the federal government has made major strides in ensuring the diligent prosecution of cases, which in effect translated into major convictions, has equally translated into major general reforms in governance through legislative, executive, and associated incidental justice sector reforms and process. The objective of this gathering and this engagement this morning has already been laid, and it is to the effect that the public, members of the press, and Nigerians are updated on the general position of things as it relates to the justice sector. It is on this basis that you have gathered here today the Federal Ministry of Justice, a delegation from the Federal Ministry of Justice, chaired or headed by the Attorney General, the General Justice Sector departments and agencies of government under the direct supervision of the Attorney General of the Federation and Federal Ministry of Justice, that are here to engage you and provide an insight associated thereto. In the course of my presentation, I will start by way of giving you an insight as to what successes, if any, has been recorded by the Federal Ministry of Justice in its own right. And then I progress and proceed to the successes, if any, that were recorded by the departments and agencies, parastatals, under direct supervision of the Office of the Attorney General, and progress further by way of addressing successes, if any, recorded by other agencies of government over which the Office of the Attorney General of the Federation exercise oversight by extension, by law and by the Constitution. Not only the ministries, departments, and agencies under direct supervision of the Office of the Attorney General are indeed involved in the justice sector administration, but by Constitution and the enabling laws, the Office of the Attorney General exercise extended supervisory role over some agencies of government. For example, when it comes to prosecution, the Office of the Attorney General has the responsibility of general oversight on all prosecutorial agencies in the country, and that role is constitutional. So now, coming to my presentation, which is indeed committed to writing, I may not necessarily be wholeheartedly governed in my presentation by the documented presentation, but then I will try as much as possible to operate within the circumference of the presentation documented as presented. Let me begin by welcoming you all to this 46th session of the weekly State House briefing, which I have the privilege to anchor. My briefing will focus on strides made under the administration of President Muhammadu Buhari, justice sector administration, and policy reforms. You may be aware that the agenda of this administration is firmly anchored on respect for the rule of law, so our efforts have been to improve the capacity of justice sector institutions, strengthen anti-corruption agencies, enhance access to justice, improve prosecutions, and asset recoveries, among others. Distinguished ladies and gentlemen, the justice sector encompasses all institutions of government involved in administration, enforcement, and dispensation of justice. This sector extends beyond the federal level and cut across sub-national entities and the three arms of government, the judiciary, the executive, and the legislature. Effective collaboration and coordination is therefore at the crux of the mandate of Federal Ministry of Justice. Consequently, this briefing highlights not only the policy initiatives of the Federal Ministry of Justice, but also extends to critical achievements in the justice sector through policies and initiatives targeted at improving legislative policies, the judicial system, correctional system, law enforcement, constitutional guarantees, and other critical components of entire justice sector system. All these are fundamental to ensuring access to justice, safety, security, and in combating corruption as well as economic and financial crimes in Nigeria. As we may all be aware, the justice sector, as with every other sector, has continued to witness some challenges, in consideration of which we made efforts to identify recurring challenges and implement to the administration, impediments to the administration of justice. Through the instrumentality of the Office of the Attorney General, all justice sector stakeholders have built consensus, which identified these challenges and resulted in development and adopted of the first ever national justice policy in 2017. Following this landmark achievement of consensus building among the justice sector stakeholders, all justice sector institutions across the country have continued to collaborate and provide frameworks for the realization of the objectives set out in the national justice policy. It is our firm expectation that the full implementation of the proposals in the national policy on justice sector would lead to greater synergy and shared knowledge amongst all stakeholders involved in the administration of justice. But what successes we are about to unfold has been the achievements under the leadership and indeed the administration of President Muhammadu Buhari are the products of that consensus. And we are happy to state that for the first time in the history of this nation, we are indeed doing wonderfully well, arising from the consensus that has been built among the stakeholders in the administration of justice. The briefing session this morning will focus on strides being made by the President Muhammadu Buhari administration in key judicial reforms and justice dispensation within the first 18 months. By way of emphasis, let me reiterate that the focus for consideration this morning is the 18-month period. Other periods of around 7 years before then have been periodically identified, but I am exclusive, concerned, restricted, and indeed focused on the 18th-month period for the purpose of this presentation. Now, starting with the Ministry of Justice, as I have stated earlier, I will begin by way of making presentation on criminal prosecution of the ministry. But let me state for the record that when I talk of criminal prosecution, there are certain undertones associated with criminal prosecution. When at a point this country was confronted with a challenge relating to the speedy administration of justice, the Federal Ministry of Justice, arising from the consensus building that sees the legislature, the executive, and ministries coming together, came off with Administration of Criminal Justice Act and its implementation, by which higher profile criminal cases were in effect by that law to be taken day in, day out, so as to enhance the speedy dispensation of justice. When we were confronted further with a further challenge associated with the fact that higher profile anti-corruption cases, those involved in them were indeed using the proceeds of the crime in contention to now force a greater challenge on what we are doing, arising from their movements, arising from the deployment of such resources, we equally came up with Executive Order number 6, which restricts movement of the higher profile, of the people involved in high profile cases, which equally restrict their access to funding. So on the basis of that, we now laid the foundation of prosecution. So arising therefrom, for example, by way of criminal prosecution in the Federal Ministry of Justice exclusively, I am not talking of the entire prosecution because other agencies of government, EFCC, NDLEA, ICPC, are equally involved in direct prosecution. So I may perhaps, maybe when I get to the presentation on the parastatals, give you further insight as to what they have done in their own case as it relates to criminal prosecution. So Federal Ministry of Justice, within the 18-month period I'm talking about, was actively involved in prosecution of 312 criminal cases for various offenses, including terrorism, maritime offenses, armed robbery, cybercrime, kidnapping, among others. We have so far, as a ministry, secured over 1,000 convictions on terrorism within the period in consideration. 1,000 convictions on terrorism. Again, convictions were secured in 45 cases by complex case group. The complex case group, for your information, is a unit established in the Federal Ministry of Justice that requires specialization in prosecution of certain special cases that borders on maritime and indeed associated special cases. And the Federal Ministry of Justice has, through the complex casework group, succeeded in securing 45 convictions that relates to maritime and special task force on electricity offenses, and that convictions were secured across 13 zones of the ministry. Participation in the Joint Investigation Committee, as you rightly know, for the success of conviction, criminal conviction for that matter, there is indeed need for extensive investigation. Not only an investigation, but indeed having an investigation report that must naturally stand the test of proof in court, which by processing must be translated and processed into an actionable evidence. So arising from the consensus building arrangement, it is no longer business as usual, where the case in contention requires multi-stakeholders, connectivity, collaboration. The Federal Ministry of Justice has created an avenue for collective participation in, as it relates to investigation. For example, if you are talking of terrorism, it is only natural that other agencies of government that are involved in an investigative process associated with terrorism cases must be involved. So, for example, the DSS may necessarily be involved, inclusive of the military in certain cases, when perhaps field operations were the product of the cases that came around us. And when you are talking of economic crime cases, for example, it is only logical that the EFCC must be involved, and governance cases, for example, the ICPC must naturally be involved. So what I'm saying, the consensus building arrangement is paying off. Paying off in the circumstances that the agencies of government are now working together for, as it relates to whatever issue is at stake. The Federal Ministry of Justice is equally engaged with the International Criminal Court and ongoing satisfactory prosecution of 7 potential ICC cases to obviate the trigger for any ICC prosecution. At the international level, for example, there are rules for engagement taking into consideration that we are engaging In the northeast, for example, the Boko Haram. In the southeast, the IPOB. And in the northwest and central, for example, the bandits and associated things. All these things, by the rule of international engagement in respect of which Nigeria is a member, there are certain code of conduct that is expected to be complied with. And when you are operating in breach of those code of conduct, the actions or inactions may eventually translate to a considerable case before International Criminal Court. So we are equally working together as a system to ensure at the end of the day that nothing adverse comes our way as a nation in terms of breaches associated with the International Code of Conduct of Engagement, both military and otherwise. Again, out of desire to deploy technology into what we are doing, as far as governance is concerned, as far as the fight against corruption is concerned, we have deployed a state-of-the-art case management system known as Intela, and this is a smart case management system that not only warehouses all terrorism-related cases from 2017 till date, but also intelligently provides needed statistics. For your information, Nigeria is not operating alone in the fight against terrorism, anti-corruption programs, and associated things. And it is only logical that information and intelligence reports have been shared. The idea of remaining analog and manual in operations, we felt, is not good enough for the system as it relates to international engagement. So we have now succeeded in putting in place a technologically based case management update arrangement, which will now enable us to respond rapidly and speedily to international inquiries arising from our international engagement responsibilities of mutual legal assistance, among others. So, on cases relating to terrorism, I'm talking of the local cases with particular reference to Kainji trial. As you rightly know, the terrorism cases have been prosecuted in Kainji. The ministry, through the complex working CCG unit, is coordinating the next phase of terrorism-related trials in collaboration with the Federal High Court, the Legal Aid Council, and the Defense Headquarters. The ministry has concluded remodeling action towards structure at the Wawa Cantonment, Kenji, to accommodate 8 courtrooms, judges' chambers, living accommodation, lawyers' dressing room, and conveniences to make them conducive for judges, witnesses, as well as defendants. So we are not only confronting terrorism head-on, but we are taking steps to make all necessary provisions as it relates to facilities and indeed a kind of having in place a sustainable arrangement for the prosecution of terrorism cases. What obtained before the coming in place of this administration was an ad hoc arrangement whereby periodically arrangements are made for prosecution of these cases. But then we are now taking steps to ensure at the end of the day that a sustainable arrangement, both in terms of facilities, structures, and indeed as it relates to capacity building, are put in place for addressing, checkmating, and confronting terrorism cases head-on. So the activities of the Ministry of Justice equally are extended to sexual and gender-based violence. In response to the growing incidences of sexual and gender-based violence in the country, the President directed the establishment of Interministerial Management Committee on the eradication of sexual and gender-based violent offenses. Further to this, the ministry established a unit. The activities of the ministry in this regard has yielded the following successes. 1, establishment of special protection team to provide access to justice for victims of SGBV This includes prosecution of these offenses. The ministry is currently prosecuting over 30 cases ranging from rape, unlawful sexual intercourse, and defilement of children, and homicide as a result of SGBV policy of the federal government. Again, we created a solution room to promote access to justice for child survivors of sexual violence in the FCT. Again, we are coordinating all MDS investigating and prosecuting SGVV cases in area of reporting of incidences, data harmonization, capacity building, and interagency collaboration. Again, the establishment of a referral pathway with relevant stakeholders to facilitate smooth administration of criminal justice, such as the EFCC on forensic, Legal Aid Council, Nigeria Police Force, amongst others. Again, designation of courts on GVV by the Chief Judge of the FCT, of 4 courts in the FCT to handle all cases of gender-based violence and deployment of interventions in this regard. Now, on prosecution of criminal matters under the mutual legal assistance. By mutual legal assistance, Nigeria is not operating in isolation as far as mutual legal assistance is concerned. Nigeria, for example, as you may rightly know, has been engaging other jurisdictions for support as it relates to fugitives and those that have indeed evaded justice. Nigeria, in return, is equally cooperating and collaborating with the international community for the purpose of building that collaboration as it relates to criminal cases, for example. And that is what is known as mutual legal assistance. It is an arrangement that allows Nigeria to reach out to international community for assistance. So the Office of the Attorney General has succeeded in executing over 350 mutual legal assistance requests and over 50 extradition requests. There are people that were alleged to have committed crimes in other jurisdictions and perhaps maybe run into Nigeria. And arising from the mutual legal assistance support arrangement entered into Nigeria and other countries, we have a responsibility on demand to look at the demand, take judicial processes and steps to ensure at the end of the day, those fugitives are made to answer to the justice of what they have done. And Nigeria had equally received and processed over 50 extradition requests among other countries. Among these are the mutual legal assistance request from United Kingdom on trafficking in person, which led to the first conviction of the offender under the UK Modern Slavery Act on 13th April 2022. Other mutual legal assistance requests from Turkey, Italy, Spain, India, and United States of America on drug trafficking and other crimes have been successfully treated. Also, the Office of the Attorney General filed extradition proceedings against suspended DCP Abubakar, for example, in line with mutual legal assistance requests from the United States of America. The matter is still ongoing before the Federal High Court. So what I'm trying to say in essence, that we have, under the leadership of President Muhammadu Buhari, not only succeeded in establishing a local consensus to justice sector issues, but have succeeded in establishing international collaboration that had indeed paid off in view of the fact that criminals that runs out of Nigeria are being indeed extradited, are being indeed brought back to the country through the art of mutual collaboration rather than from the mutual legal assistance. But it may interest you to know that the mutual assistance request process is not only a function of enforcement. Necessary foundation was indeed laid by having a mutual legal assistance act, which was indeed passed into law by the government of President Muhammadu Buhari, and that is what laid the necessary legislative foundation for international engagement. Now I come to the asset recovery. Before coming in place of the government of President Muhammadu Buhari, the idea of international recovery of looted assets was not in any way coordinated, organized, and indeed enhanced through processes and procedure. So in line with the cardinal principle of the administration of President Muhammadu Buhari in the fight against corruption, we have achieved the following successes under the asset recovery and management effort of this administration. But let me reiterate further that what I am presenting in terms of successes associated with recovery were successes relating to the period under consideration. But by way of emphasis and perhaps referral to the future, previous successes, I think it is important to state on record that among the major recoveries made by the Office of the Attorney General was the $322 million recovered from Switzerland, which money was indeed deployed by the government of President Muhammadu Buhari in reduction of poverty. And that was what was used arising from the international understanding, international consensus in the trader money, earn power, school feeding program, and associated social investment programs, and that had indeed translated to a massive reduction of poverty in this country. We have equally, for the record, recovered additional $311 million from US and indeed the UK, which money was in effect deployed in the execution of 3 major capital projects in Nigeria. I am talking of Second Niger Bridge, talking of the Lagos-Ibadan Expressway, talking of Abuja-Kano Expressway, which projects had indeed reached advanced stage. So for the first time in the history of this nation, recoveries were not only being made, but what they are deployed in terms of development of the nation are indeed being visibly seen. Now, coming to the period in consideration, which is the 18-month period we are talking about. I start with revenue generation and sale of forfeited assets. You are aware that the President has put in place interministerial committee that was saddled with the responsibility not only of identifying the forfeited asset, but indeed disposing them. So that committee has been working, and a total sum within the period in consideration of 18 months, a total sum of 1,823,788,146 naira 86 kobo has been generated so far from the sale of bid forms, because forms were sold for those that are interested to partake, and the actual sale of forfeited properties within the period of 18 months under consideration. Again, stamp duty recoveries. Arising from the legislations, the Office of the Attorney General is saddled with the responsibility of effecting recoveries. Among the recoveries that are legislatively sanctioned for the Office of the Attorney General are stamp duty. So an inter-ministerial committee on the audit and recovery of back years on stamp duty, because there has been a backlog, and then the need for recovery of such backlog from agencies, from indeed corporate bodies, among others, arose. So we put in place steps to ensure the recovery of these back years stamp duty. And I am happy to state that inter-ministerial committee engaged various recovery agents to recover and generate additional revenue for the government. This exercise also provided job opportunities for over 1,000 professionals, including lawyers, accountants, auditors, and financial consultants. The ongoing exercise has so far led to the recovery of the sum of 596,055,569 naira 47 kobo. International asset recoveries. Within the period under review, the 18-month period in contention, we have equally succeeded in making some international recoveries. In complying with the presidential mandates and foreign judicial processes, the ministry has recovered a total sum of 6,324,627.66 euro from various jurisdictions. And some of the recovered funds are equally being utilized in the financing of critical infrastructures, including Abuja-Kano Expressway, Second Niger Bridge, and Lagos-Ibadan Expressway. For your information, as it stands today, there exists a funding gap of around 329 billion naira, and the Office of the Attorney General, through these local, international, and associated corporate recoveries on stamp duties, is equally making drastic efforts to assist the federal government in ensuring that this project, the gap associated with the funding as it relates to these projects, are being addressed. So as a ministry, we are not only involved in prosecution, we are not only involved in fight against corruption, but we are deeply rooted in supporting the good governance of the administration of President Muhammadu Buhari as it relates to infrastructure funding arrangement. So due to the concerted effort of the office in conjunction with the relevant stakeholders, inclusive of the legislature, the President recently assented to Proceeds of Crime Recovery and Management Act 2022. For the purpose of institutionalizing the asset recovery program, the federal government felt there was a need to institutionalize it and have in place a legislative framework, because it is the foundation for the institutionalization and success of anything. When we took decision as a nation to fight corruption, we had in place legislations that put in place EFCC, ICPC, Code of Conduct, among others. And now we have taken a decision as a nation to institutionalize asset recovery. There is need as well to institutionalize them. And then how do we do that? We first have in place a demonstrating unit, asset recovery and management unit, which we realized had indeed paid off, taking into consideration the successes being recorded, and then we now have taken further steps in 2022 to have Proceeds of Crime Recovery and Management Act 2020, which is intended and targeted at institutionalizing the asset recovery process, both in terms of transparency, in terms of accountability, and in terms of institutionalization of SEM, to have in place a unit, an agency, an arrangement that stand the test of time, both in terms of transparency, in terms of accountability, and in terms of international best practices. So I now go through the impact of litigation efforts on the economy. In terms of litigation we are involved, I have given you an idea as to what we are doing in terms of checkmating criminalities in our system. I have given you an idea as to what we have done as a ministry in terms of supporting the infrastructural development of the nation. So I will now go to the specifics and give you an insight as to what we have indeed succeeded in doing through litigation in the art of supporting our economy. For the record, a total of 648 cases were instituted against the president, federal government, and its agencies before states, federal, and ECOWAS courts. And we were expected as a ministry to defend the federal government, ministries, departments, and agencies in that respect. The cases that were instituted, I'm talking of the 648 cases that we are defending against the interests of the federal government, are at different stages of trial. But one thing I can tell you clearly, and I wish to emphasize, is the fact that the Federal Ministry of Justice has indeed been diligent in providing the necessary defenses in support of the federal government. By way of digression, let me tell you, before this government comes in place, a lot of judgment debts were incurred, inclusive of the Paris Club that constitute a contentious subject of contention in the system. But one thing I can clearly say, ever since the coming in place of government of President Muhammadu Buhari, not a single major higher profile judgment was entered against the federal government. All the judgment debts in contention that we are battling to defend were indeed inherited judgments against the interest of the federal government incurred by the previous administration and certainly not by the administration of President Muhammadu Buhari. So, arising from the diligent defenses we have been undertaking, we have succeeded within the period of 18 months in addressing and avoiding liabilities on the part of the federal government that run into around 54 billion, 888 million, 343,888 naira 52 kobo in naira. Those cases we diligently, successfully defended the federal government, which translated into naira and kobo avoidance of liability. Again, we have equally succeeded in defending the federal government to avoid liability in the sum of $507 million, $507,415,901.19 million. So these cases were handled by the State Council in the office of the Attorney General of the Federation, and not a kobo, was paid by the federal government as professional legal services for the defense of these cases. What I'm trying to state in essence, that we have succeeded as a ministry in building capacity of the lawyers in the office and in the chambers of the Attorney General, and they are these lawyers that have indeed succeeded in recording this feat in defense of the federal government. The ministry is also coordinating the defense of a number of international arbitration proceedings commenced against the federal government, which were rooted in the previous administration, mostly. Of special mention is the case of P&ID, in respect of which an arbitral award of 10 billion was inherited by this government. And as at the time we came in place as a government, this award was at the point of execution. But for the purpose of emphasis, let me state that the volume of the $10 billion arbitral award against Nigeria has the capacity to set us back in terms of healthcare, in terms of security, in terms of education. All what we have been witnessing in terms of military procurement couldn't have been possible if indeed that judgment was indeed executed against the interest of the federal government. So we have, for the first time ever, established a precedent. What precedent is that? That judgment, as at the time the government of President Muhammadu Buhari came in place, was already in place, and the time within which even to appeal against same had elapsed, much less of the time to seek for any stay of execution, among others. We have succeeded in putting in process, on account of which for the first time was not only extended for the federal government to put in process for consideration, but then this judgment was stayed, and then we were asked as a nation to deposit 200 million pounds as a condition for stay of enforcement. We further took steps to challenge that aspect of the judgment of the order that says a federal government must deposit cash, 200 pounds cash. We challenged them, and we succeeded in setting aside the order demanding the deposit of 200 million pounds. And as it is today, we are happy to state that we have not only succeeded in staying the enforcement of the judgment, but are given an opportunity to contest test the judgment, and we are hopeful. By God's grace, we shall triumph. So the ministry indeed had equally taken steps to defend the federal government in cases like arbitral proceedings relating to Sunrise Power, relating to Mambila, and a host of others, including of many others that we have won along the line. Now, coming to contract negotiations, as at the time the government of President Muhammadu Buhari came in place, we inherited contracts that were a product of in-house compromises, whereby, in effect, breaches are naturally triggered. And we have taken steps for the first time to ensure that contracts are not only vetted, but indeed they are vetted with exclusive public interest component in consideration as it relates to betting same, thereby ensuring, above any other thing, that the interest of the nation is put at heart. And indeed, those contracts, for your information, within the period under review, the ministry has reviewed about 392 major contracts and PPP projects to ensure value for money, eliminate corruption, and ensure adequate protection of the federal government of Nigeria investments. We have witnessed, among others, contracts that have clauses that exposed not only the investment of the federal government, but indeed even our foreign reserves in the event of default. And by collective, perhaps, conspiracy among the syndicates associated with these contracts, defaults were indeed compromised. And then, even if we have the wherewithal as a nation to ensure that no default is occasioned, a compromise, a conspiracy is hatched among the people of interest that now will trigger the act of violation of the agreement. One single agreement that was indeed inherited by this government was an agreement in which the federal government of Nigeria was made liable to $1 million daily in the event of breach. And that has to do with the power generation contract, among others. So the government of President Muhammadu Buhari has succeeded in turning things around to ensure that the national interest constitute the watchword in whatever we do as it relates to contract betting and processing. In the case of ease of doing business as well, the Federal Ministry of Justice has worked extraordinarily hard in ensuring, at the end of the day, that necessary conducive business environment has been put in place. And that eventually has translated into a number of international acknowledgement of the fact that Nigeria is indeed conducive environment for investment. Again, in the act of negotiating and facilitating loan facilities on behalf of the federal government, which function is equally a function that the Federal Ministry of Justice has a role to play, the Federal Ministry of Justice provides legal support during negotiations for loan facilities from international organizations, including the World Bank, African Development Bank, China Exim Bank, among others. Our efforts so far as a ministry have ensured that these loan agreements do not impose onerous conditions in the contract which may turn out to additional liabilities. International economic cooperation. The ministry has continued to work towards improvement in bilateral relations with other nations through the preparation and vetting of agreements, memorandum of understandings aimed at attracting foreign investments, and has vetted and cleared over 250 agreements. In July 2022, oil and gas-related matters were negotiated, and relevant instruments executed during the visit of President Muhammadu Buhari to Spain and Portugal. Nigeria also negotiated and signed agreements, memorandum of understandings with Ivory Coast, Burundi, Rwanda, Turkey, South Africa, Iran, Benin Republic, Netherlands, United Arab Emirates, South Korea, among others, all targeted at enhancing our economic well-being as a nation, and indeed the fight against terrorism and money laundering, among others. Again, the Foreign Ministry has played a major role in ratification of international treaties on security. A few weeks ago, the Ministry of Justice facilitated the ratification of Nigeria's accession to Budapest Convention on Cybercrime, which was assented to by the President on 4th July 2022. The Budapest Convention on Cybercrime is the sole international instrument on cybercrime, which sets out the framework for harmonizing criminalization, procedural powers, and international cooperation. Without this ascension, Nigeria could not be benefiting from international understanding on sharing of intelligence associated with cyber crimes internationally. Now, in terms of legislations as well, the Federal Ministry of Justice support government revenue generation drive through policies and role in the promotion of economic focused bills and executive orders aimed at creating jobs for the teeming population of Nigerians. It does this by initiating and development of legislations, policies, orders, and regulations that promote socio-economic development of Nigeria. For the record and emphasizing, the ministry has processed over 50 critical legislations which are targeted along different sectoral needs, which encompasses security as it relates to security and the national defense. For example, 2 bills were processed. Social intervention, 1 bill. Education, 20 bills, inclusive of bills that establishes educational institutions across the nation. ICT-related matters, 2 bills. Sports, 2 bills. Environment, 3 bills. Judiciary, 2 bills. Foreign affairs, 3 bills. Agriculture, 3 bills. Finance, 3 bills. Executive orders relating to orphan defecation, concession of tax, maintenance of public building, and ECOWAS early warning and response mechanism, 15 regulations relating to agriculture, environment, oil and gas, finance, stamp duty, among others, gazetting of practice directions for the High Court on terrorism trials and AMCON cases, among several others. So what I'm laboring to state in terms of legislation, the Federal Ministry of Justice is indeed all-encompassing. We keep watching the trend, security, economic, education, and associated incidences that have a direct bearing on the development of this great nation of ours, and we keep coming with bills that have the capacity to provide the intermediate result, both in terms of the development in our economy, development in infrastructure, judiciary, legislature, among others. For the record purposes, I think one example is important. When we come to realize that the autonomy of the judiciary is being threatened, the autonomy of the state legislature is being threatened, we supported the idea of amendment to our constitution, on account of which Section 121 was indeed amended to provide the desired support in having in place autonomy, both in funding and in administration of the legislature and the judiciary, among others. So, major terrorism trials and AMCON cases, among others, were equally factored into consideration. Major bills developed and reviewed by the Federal Ministry of Justice within the period to which the President has granted assent were include indeed, among others, the following. I am now talking specifically on those bills that were indeed assented to by His Excellency President Muhammadu Buhari, account of the legal opinion developed by the Federal Ministry of Justice and their effect in the economy and in the development of the nation. Of recent, Mr. President has assented to climate Climate Change Act 2022, and that is indeed a proof of the sensitivity of the president to our climate. Again, Money Laundering Prevention and Prohibition Act, which is intended to enhance what we are doing in terms of the fight against corruption, was equally passed in 22, Money Laundering Prevention and Prohibition Act 2022. Terrorism prevention, which is a response to enhance consideration of what we need to do as a nation to fight terrorism. And as arising from that, Mr. President assented to Terrorism Prevention and Prohibition Act 2022. I'm talking of the period, restrictive period of 18 months that is under consideration for the purpose of this presentation this morning. Again, Electoral Act 2022. When the need arises to deepen our democracy, Mr. President, in line with his avowed commitment on democracy and democratic process, has assented to Electoral Act 2022. Again, in the course of my presentation earlier, I made a submission relating to Proceeds of Crime Recovery and Management Act 2022. It is equally targeted as bringing about the desired transparency, accountability, and institutionalization of the asset recovery and management process under the administration of President Muhammadu Buhari. Again, of a major support to the economic well-being, Federal Ministry of Justice was instrumental to the drafting, packaging, processing, and presentation before the National Assembly of the Petroleum Industry Act 2021. These are to mention but a few. On those legislations of recent within the period we are talking about, and we have, over and above this, a lot of other bills that have educational undertones, that have associated undertones, all targeted at bringing about the desired development of this great country of ours. I now address equally the criminal justice sector reforms. What are the reforms, if any, that we have succeeded in bringing about as it relates to the criminal justice sector reforms within the context of the time under consideration? Due to the inadequacies of the postal institutions and the remand centers and the adequacies associated with the prevailing act, which was contained in, which is an act, laws of the Federation 2004, we consider the need to holistically address the protection of children, a situation whereby children are indeed kept in correctional centers, formations across the nation is not good enough for us. There should be separate provision for the children, and we came up with the need to make certain amendment to that, and then we develop the Children and Youth Correctional Center Bill 2022, which will repeal the Postal Institution and Remand Center Act 2004, which to our mind is indeed archaic and does not address the problems we are facing now. The aim of the bill is to align it with the provisions of the Child Rights Act and other international conventions on protection of children and young persons. Again, to decriminalize the treatment of children and young persons in conflict with the law and establish an improved legal and institutional framework for protection of children and young persons. I now come to the domestication passage of the Administration of Criminal Justice Act. As I've stated earlier in this submission, I stated that the Administration of Criminal Justice Act was targeted, among others, in the provision of speedy determination of justice. Cases that have been there on before the coming in place of the government of President Muhammadu Buhari that had not recorded an inch progress for over 10 years are now being speedily determined within a period of 6 months, among others. So with that realization of the success associated with the Administration of Criminal Justice Act, we have now developed a policy of engaging subnationals, I'm talking of states, to consider the possibility of domesticating same, so that the speedy determination of justice, among others, is not localized to federal offenses, but indeed is indeed applied as well as it relates to the prosecution of cases at the state level. So the ministry has, in pursuance of this consideration, vigorously pursued the implementation of these fundamental provisions of the Act through robust oversight functions by the judiciary over police cells and other detention facilities. You are no longer hearing about awaiting trials, perhaps maybe the congestion in the prison formation. It is a provision embedded in the Administration of Criminal Justice Act that now makes it an offense to the prison formation to accept inmates in cases where their limit has been indeed, where they have exhausted their accommodation limit. That now is now making the awaiting trial and decongestion in our correctional centers formation a history. Nobody is shouting at the rooftop over the awaiting trials and congestion in prison formations, among others. So again, through the implementation of the Act, several sensitization workshops are now taking place for the purpose of encouraging states to indeed consider domestication. And we have equally come about with development of a plea bargain and confounding offenses guidelines for the prosecutors. A situation whereby someone is alleged to have indeed to have stolen 1 billion and then he is given a fine of 100,000 to now go scot-free is no longer obtainable, arising from the consensus building arrangement relating to the practice direction and indeed sentencing guidelines and plea bargain. So things are no longer left to exclusive discretion, but they are indeed legislatively regulated. I will now, with your permission, proceed to the parastatals under the direct supervision of the Federal Ministry of Justice. I'm talking of direct. In the course of my submission earlier, I stated there are those that are directly under the supervision of the Federal Ministry of Justice and those that are by legislative extension also being supervised by the Federal Ministry of Justice. I will now start with those that are under direct supervision. Nigeria Law Reform Commission. The chairman is here with us this afternoon in case there are questions that relate to these agencies. I urge you to spare me the trouble of answering them and passing them on to them. The Nigeria Law Reform Commission was established to undertake research into and review all federal laws with a view to their systematic and progressive development and reform in consonance with the prevailing norms of Nigerian society. In pursuance of its mandate, the Commission has successfully carried out the following: review of Code of Conduct Bureau and related provision of the Constitution. Our society is dynamic. Things are changing, both in terms of technology and associated consideration. And our laws must as well be dynamic in terms of accommodating the new trends emerging. With that consideration in mind, the the Law Reform Commission has reviewed the Code of Conduct law with a view to bring it to terms with the current realities, both technological and otherwise. Equally, the Law Reform Commission is reviewing our tax laws in Nigeria, Companies Income Tax Act, to make it more viable in terms of bringing additional revenue to the government. Again, completion of the law reform and unification of the criminal and penal code. As you rightly know, Nigeria operates dual regime criminal code arrangement, Criminal Code Act for the South and then Penal Code for the North. And the need arises for unification purposes to consider the possibility of unification of same Code of Conduct. Law Reform Commission is looking into that and is working in that direction. Review of tax laws in Nigeria, personal income tax, CAF P8, Laws of the Federation 2004. The reform of the Act is in furtherance of the government economic reform policy to engender economic development of the country. I now come to the second parastatal, the Council of Legal Education, Nigeria Law School. The Council, the Nigeria Law School, as you rightly know, is responsible for the production of lawyers and sending them across to practice and act as lawyers across the nation. By way of achievement, the Council of Legal Education has achieved the following. In the period under review, the Council has commenced a program to admit graduates from National Open University of Nigeria, which commenced in 2021. Before the coming in place of the government of President Muhammadu Buhari, those that have indeed enrolled in the Open University programs as lawyers could not gain admission in the law school. But we felt it is unfair, having put in place by legislative process an institution has produced graduates, and you cannot accommodate them to practice law, even when they are indeed confirmed and ascertained to have indeed studied law and are eligible both in learning and character. And then the Council of Legal Education look into it, and then under the period under review, the Council has commenced the program of admitting them. That is justice for you, for President Muhammadu Buhari. If you do not believe in a program, don't put it in place. Again, the Council, by the policy of the Council, universities are expected to be regulated in the number of the candidates they admit annually to study law. But arising from the impunity that has characterized our system over time, some of these universities exceeded the regulated limit. It's as good as Nigeria enrolling as an OFEC member, and it is given a production line of 1,000 barrels per day, and then Nigeria took a decision to produce 1 million barrels. The implication is you will have a backlog of over 900,000 that you will have nowhere to sell. So over time, before the coming in place of the government of President Muhammadu Buhari, there were a lot of lawyers, graduates in law, that could not be admitted in the law school because of the impunity of their university system. So a decision was taken with the compassion of President Muhammadu Buhari in mind to ensure that the backlog of over 10,000 students arising from over-admission by some universities are addressed. And I'm happy to report that that is being addressed, and they are given an opportunity to enroll and register at the law school and practice eventually upon successful completion of the program as lawyers. Again, enhancement of curriculum and adoption of interactive method, which has made the program at the school more student-focused, aligned with the law and vocational nature of the school, as well as the best practices. And the Council established quality assurance unit to ensure uniform delivery of academic programs across its 6 campuses. Nigeria Law School has 6 campuses, and quality assurance is considered for the first time under the leadership of President Muhammadu Buhari, that we cannot tolerate a situation whereby you have someone produced as a lawyer in campus A that is half-baked, and then having someone produced as a lawyer in campus B that is fully baked, which in essence underlies the uniformity and the need for universality of approach as far as the lawyers' curriculum is concerned in the country. The Copyright Commission, Nigerian Copyright Commission too, is here. They have equally supported the nation, supported the system in what they do by way of their mandate as a commission. The commission is responsible for information for the promotion, administration, regulation, and enforcement of copyright in Nigeria. It is instructive to note that the act establishing the commission is currently undergoing review. The bill provides for the increase of standards of protection, appropriate exceptions, increased sanctions against criminal infringement, and addresses online infringements, thereby improving the administration of copyright. For the first time under the leadership of President Muhammadu Buhari, the need arose to provide protection to intellectual input, intellectual creativities. And that is what the copyright is intended to achieve. The Copyright Bill 2022 has in effect been passed by both the Senate and House of Representatives and now awaits transmission to the President for assent. The Commission has achieved the following, among others: development of model intellectual property policy for Nigerian universities and presented to all vice chancellors to enhance commercialization of research work, innovations, and creativity in their universities. So a platform, a legislative platform, has been now put in place to ensure that research work are indeed not only protected, but then are commercialized for the purpose of the artists enjoying the benefits of their labor. We concluded, the Commission concluded 986 strategic anti-piracy operations in different piracy hotbeds across Nigeria and arrested 370 suspected pirates. In the course of the operation, 3,439,838 pieces of assorted pirated copyright books with estimated market value of 3,318,670,810 naira were confiscated. Collaboration with the Nigerian Customs Service to inspect and clear hundreds of shipping containers and impounded 38 found to contain pirated books, music, and films in Lagos and Port Harcourt was achieved, among others, by the Commission. Again, the Commission has succeeded in destroying 27,316,187 units of pirated copyright works with estimated market value of about 3 billion, of over 3 billion, and secured 68 convictions of copyright infringements. Legal Aid Council. The mandate of the Council is to provide free legal assistance and representation in all criminal matters and to Nigerians in conflict with the law in civil dispute in order to promote access to justice. It is common knowledge that not all Nigerians could afford the services of lawyers. And arising from the further compassion of the President Muhammadu Buhari, a decision was taken to support the Legal Aid Council to indeed stand to its mandate by providing legal services to indigent Nigerians that could not afford the services of lawyers in defense of their cases. So in the period under review, the Council has undertaken the following. Legal aid services were provided to about 57,134 citizens free of charge. Again, the Council has recovered the sum of 57,390,928 naira 0.62 kobo as being compensation for victims of road accidents. We are living witnesses to the fact that a lot of Nigerians could not pursue their claim, particularly as it relates to road accidents, among others. The Legal Aid Council has taken it upon itself to support those Nigerians that could not afford the legal services. And arising from that, the Council has recorded success of getting compensation in the sum of over 57 million for this type of Nigerians. Again, the Council provided defense for about 224 suspects arraigned before the Federal High Court for the offenses of terrorism. A special task force has also been set off by the Council to speedily handle these cases, and this led to the recent release of awaiting trial suspects, about 30 of them from KP correctional centers. These add up to what we are doing in terms of the congestion of prison formations. Again, the Council filed applications for the enforcement of fundamental rights of 101 awaiting trial inmates at Kirikiri Maximum Correctional Centers who have spent over 10 years in custody without trial before the Federal High Court in Lagos. The conventional practice is to commit people to prison, and they are forgotten because they cannot afford the services of the lawyers, and they remain there perpetually. Some of them, as can be seen from here, have been there for over 10 years, and their cases were not in any way taken. The Legal Aid Council has now provided the desired aid, and in so doing, filed necessary applications on their behalf for enforcement of fundamental human rights. You cannot commit me to prison custody for 10 years for an offense that naturally perhaps may take just 2 years to conclude, simply because I'm not presented before a court of law for consideration. The compassion associated with the Legal Aid Council requires that in such cases, identify them, take off their fight, file the necessary application on their behalf before a court of law for enforcement of their fundamental human right, which has been breached arising from the fact that they have been unnecessarily kept in custody without trial, and that they have succeeded in filing over 101 cases within the period under review. I am also pleased to report that the police duty solicitor scheme currently operates in 11 states across the country, including Kaduna, Ondo, Imo, Sokoto, Federal Capital Territory, Kebbi, Edo, Bayelsa, Rivers, and Plateau states. This operation has successfully diverted over 7,000 persons from the criminal justice system, and 90% of this number left police custody during their first 5 days. The traditional practice before coming in place of this government is to take people to police custody and keep them there for 1 year, and in some cases, 3 months and above. Now the Legal Aid Council has come in place that no, you must be taken to court if indeed there is a strong case against you. And arising from that, they have succeeded in ensuring that people are no longer kept in police custody longer than 5 years on account of their intervention. Now, the National Human Rights Commission. In line with its mandate made under the law, which is the protection and promotion of human rights in Nigeria, the Commission has established a mediation center, a counseling and trauma unit, as well as 24-hour National Human Rights Commission toll-free call center for reporting cases of human rights violation. Out of desire to establish the desired connectivity between Nigerians and the Human Rights Commission, a call center is now established. The implication is if your rights are abused, you can make immediate call to the Human Rights Commission, and they come in to intervene and ensure what justice is done to you within the context of the law. So following the anti-SARS protest across the country in October 2020, the Commission established the Independent Investigative Panel on the defunct SARS and other units of the Nigerian Police Force, IIP-SARS. The panel received 279 petitions from 29 states in Nigeria, and at the conclusion of deliberation, ensured payment of compensation of over 146 million to 26 petitioners in December 2021. Another batch of 75 petitioners will be paid 289 million naira at the end of August 2022. What I am trying to state, in essence, is before the coming in place of the administration of President Muhammadu Buhari, we have no record of payment of compensation to victims of human rights abuses. But for the first time in the history of Nigerian state, Human Rights Commission is no longer backing, but is in essence biting and ensuring at the end of the day compensations where they are deemed necessary are indeed paid. In addition, the panel supported 23 state panels of inquiry with training and staffing. Human Rights Commission, in collaboration with the Prime Minister of Justice and other stakeholders, held successful campaign and creation of national awareness on sexual and gender-based violence, leading to the declaration of national emergency on SGVV in 2021. Now, the National Institute of Advanced Legal Studies. We have talked of consensus building. We equally talked of capacity building. We equally talked of emerging new criminalities setting into the system. For example, the piracy was not a crime that has a traditional history, particularly as it relates to the Nigerian state. When in effect, these emerging criminalities are coming off, it is only logical that there is need for capacity building. And that is what Nigerian Institute of Advanced Legal Studies is set to achieve, among others. The institute has the mandate to conduct research into any branch of law with a view to providing information, supervision, guidance, and advice to the postgraduate students and other researchers in the field of law and related subjects. So the institute succeeded greatly in enhancing the capacity of about 897 states high court judges. So these high court judges have been trained periodically as it relates to emerging new trends, both in criminality and associated legal development. And the institute has indeed, over time, within the period in consideration, succeeded in building the capacity of 897 state high court judges across the 36 states of the Federation, including prosecutors and defense counsel in the State Ministry of Justice, as well as police, prosecutors, and the Nigerian Bar Association. The institute has also contributed in critically assessing the level of implementation of administration of the Criminal Justice Act in the rules of court and practice direction by generating case laws of direct application to the implementation of the Criminal Justice Act and states level and AGJA at the federal level of the judiciary. Again, the institute has produced a compendium of comparative analysis of the various states and state administration of criminal justice law and how they are compatible with the federal legislation. This is targeted at pointing out the differences at the maximum level of compatibility for better understanding of both lawyers, law teachers, as well as members of the judiciary at the federal and state level. I now proceed to the National Drug Law Enforcement Agency. The profile of Nigeria's drug control programs has indeed risen remarkably well, for that matter, under the leadership of President Muhammadu Buhari and the chairmanship of General Buba Marwa, the chairman. Particularly within the period covered by the briefing, narcotic interdiction capacity has improved at our airports, seaports, and land borders. Interestingly, the deployment of cutting-edge technology like drug detecting scanners and Alethea, permit me my pronunciation of it, eye-based lie detector. If you have drugs in you and then you are subjected to the lie detector, it tells. And it has proven to be very effective. I am not sure of the percentage, but I believe more than 90% efficiency. They are deployed under the leadership of the chairman, and this has translated to major breakthroughs as far as the fight against illicit drugs is concerned. This has led to increased drug seizures and the apprehension of suspected drug traffickers. Also, the strict adherence to intelligence-led enforcement practices has resulted in the arrest of drug barons and the dismantling of several drug trafficking cartels. Before coming in place of this government substantially, what NDLEA was targeting were the petty drug addicts. And then hardly you find an attack relating to the barons and cartels. That has been indeed, that story has changed. Other significant operations conducted by the agency within the period under review are as follows. Establishment of a 24/7 toll-free call center, additional technological innovation, toll-free call center. The implication of this, there was a time for information that shortly after coming in place of this government, we had an information relating to bringing into the country about 40 containers of the codeine, you call it, and efforts were being made by people that were in the know to relate that information to the system. It became very difficult. With the free toll call center now, they are no longer bound to be going in cycles, but can call the chairman directly and pass on their information, and they have a reputational record of rapid response to information as received arising from the toll-free center arrangement. It has indeed, the call center arrangement has led to increased drug seizures and apprehension of suspected drug traffickers. Also, the strict adherence to the intelligence-led enforcement practices has resulted in the arrest. Again, dismantling of 2 clandestine meth laboratories used for the production of methamphetamine. Is it the way it is pronounced? Commonly known as ice or purumiri. That is a common name in the Igbo land. Yeah? Ipurumeri. In the Igbo land, that is the way it is called. And the labs were located at Victoria Garden City, Lagos State, and Nisi community in Anambra State. Again, the NDLEA has succeeded in arresting 17,444 within the period under review, males and 1,496 females, with a total of 3,657,185.8 kilograms of narcotics drugs, and psychotropic substances, which were indeed seized. It also won 2,904 cases charged with various drug-related offenses. This is the story of successes being recorded by the government of President Muhammadu Buhari within a period of 18 months. Now, harm reduction policies also, opioid substitution therapy, needle and syringes programs, HIV testing services for drug injecting users, hepatitis prevention, diagnosis and treatment, medically assisted therapy, and other evidence-based drug dependence treatments are among the ongoing interventions being provided by the agency. I now come to the Regional Center for International Commercial Arbitration. The major international functions or powers of the center are 2. The promotion of international arbitration coordination, assistance to existing arbitration institutions, among others. And the center caters for the needs for arbitration communities in the areas of promotion, assistance, and capacity building. So these agencies of government, as you can see, have equally, in their own right, succeeded in supporting what the government of President Muhammadu Buhari have done. That was it about the parastatals and agencies, commissions under the direct supervision of the Office of the Attorney General. Now, by way of conclusion and rounding off, let me perhaps maybe cite a simple example of those agencies under extended supervision of the Office of the Attorney General, arising from the law, legislation, or the Constitution. I will give you one example. All of them are indeed doing wonderfully well, but for example purposes, I will give you a comparative history of what it has been as it relates to convictions by these agencies of government. Maybe I cite one example of the EFCC. As at 2015-2016, when we came in on board as a government, the number of convictions recorded by EFCC in the year was 195 convictions. Now, what happened after coming in place of the government of President Muhammadu Buhari? In 2017, for example, we realized that the convictions recorded had not significantly improved. And in 2017, as a result, we had 189 convictions, while in 2016, we had 195. And we said, no, it can't happen. It's never our fortune. Our fortune is success and not a failure. So what is it that we have done? In 2018, we intensify our efforts associated with legislation, associated with training, associated with international collaboration and consensus building. What was the result of that engagement? In 2018, the conviction rate of the agency or commission enhanced to 312. We won, double off, and they did. So as at 2019, the level of convictions recorded by EFCC was enhanced to 1,280, and that was 310% enhancement in convictions. But the most interesting aspect of it is the 2020. That was the period under COVID, where indeed we imbibed a further technological advancement policy of having virtual court proceedings. And even with the restrictions, impediments brought about by COVID, EFCC recorded 976 convictions in 2020. But then, the story has further enhanced, changed, and progressed. As of 2021, we recorded the commission recorded 2,220 convictions, and that is 127.5 enhancement in the recorded target. And now we are in 2022. And which quarter is it? Third quarter, is it? We are in the third quarter of 2022, and we have recorded 2,141 convictions by EFCC. And the story I am telling you is the same as it obtains to the ICPC. Not only in terms of convictions, but in terms of the recovery of the assets. Our capacity and the capacity of our institutions to detect criminalities with financial undertones has been further established by what is unfolding in the system. Around 80 billion taken out of the system through a compromised technological arrangement were identified. Our preventive measures are equally working. So, distinguished members of the press, I thank you most sincerely for according me this opportunity to engage you this afternoon. Thank you.
Without doubt, the Attorney General has done a lot of justice to what we laid before him. And if I didn't hear anything, what struck me most was saying that this administration has not incurred any judgment debts, and that the lawyers from the Federal Ministry of Justice have actually been doing their jobs diligently. No need to hire and pay lawyers fat amounts. I think that is highly commendable. Before we go asking the questions, let me also say it that because of the very expansive, not a lecture, briefing that he has given us, we will not have the liberty of having too many questions, because I'm sure he has addressed a lot of these things. So, who asks? Yeah, we know current issues. We have an idea. Yeah. Juliana 1, Tribune 2, TVC 3, Silverboard 4. 4 for now, then harmonize the other 2 questions. We will take 2 more after these 4. So anyone that I have not asked, I have not called, harmonize your questions. I will take 2. Of course, we still go online too. Go ahead, please.
Good morning. Good afternoon, sir. Yes. Good afternoon, sir. Okay, my name is Juliana Taiwo Balonye of the Sun newspapers. So I will start with a recent development. Your aide, Ladidi Mohammed, head of Assets Recovery and Management Unit in your ministry, when being probed by EFCC for oversale of recovered assets, said she acted under ministerial instructions. So I'd like to have your reaction on that, sir. Thank you.
Thank you, Sarah. I want to applaud you for the very concise presentation you made, sir. But there's, even though you spoke, flickingly on the Paris Club reform, I want to raise a point here that has engaged the media or the public in the last few days. And we have reports that despite the presidential directive to suspend the deductions from the Paris Club reform, that there has been there's some evidence that that directive has not been fully complied with, because some deductions have been made and some contractors have been paid. We just want you to put a little clarity on that. What do you have to say to it? Thank you, sir.
Good afternoon, Senior Advocate, and good afternoon, sirs. My name is Femi Akonde from TVC News. Yes, sir. First, I must commend your presentation and the achievements under your watch as Attorney General. Sir, there is an impression out there. You talked about convictions made by the EFCC and how it has increased over the years. But some people would say that it seems the EFCC is focusing on cyber crimes, which of course is a crime on its own, but they say when it comes to corruption within the government, that it appears as if the wheel of justice grinds slowly when it comes to putting the searchlight on corruption in government. I would like you to react on that, sir.
All right, sir. Good afternoon, all. My name is Ondunaiga from Silverbird Television. So, at the very start of your presentation, sir, you made mention of the fact that you have secured over 1,000 convictions of actors of terrorism. So, just by way of clarification, how many of these were committed? How many of these people were committed to death sentence, and others just getting various sentences? Thank you.
Let me begin by addressing the first question by Juliana of Sun newspaper as it relates to the issue that borders on forfeited assets and its disposal at the Federal Ministry of Justice. As you rightly know, that subject is indeed a subject being investigated by the EFCC, and it is only natural that we should allow investigation to take its natural course. As the Chief Law Officer, I wouldn't like to be preemptive of any investigative process, taking into consideration that there is need to cover the field and indeed cover the cycle. So I wouldn't like to comment one way or the other in view of the tendency of investigation over the matter. On the issue of Paris Club that is raised, You mentioned that there are directives that payment should not be made, and then in breach of that presidential directives, payments were perhaps maybe arising from the conspiracy between the Attorney General of the Federation and Minister of Justice. Payments have been made. I think you need to be informed first as to the antecedents, prevailing circumstances, and how the liability arose. But one thing I'm happy to state, which I want to reiterate, having stated same earlier, is the fact that the Office of the Attorney General and the government of President Muhammadu Buhari has not indeed incurred any major judgment debt for the period of 7 years it has been on. Now, coming to the antecedents background of the Paris Club. The liability or judgment debt relating to Paris Club was indeed a liability created by the Governors Forum in their own right. How do I mean? The Governors Forum, comprising of all the governors, sat down, commonly agreed on the engagement of consultant to provide certain services for them relating to the recovery of the Paris Club. So it was the Governors Forum and not the federal government in the first place that engaged the consultant. Two, when eventually successes were recorded associated with the refund associated with Paris Club, the governors, collectively and individually, presented a request to the federal government for refund. And among the components of the claim presented for the consideration of the federal government was a component relating to the payment of these consultants that are now constituting the subject of contention. So the implication of that is that the governors in their own right recognized the consultant, recognized their claim, and presented such claim to the federal government. Three, when the claims were eventually processed and paid to the to the Governors Forum, they indeed on their own, without the intervention of the federal government, took steps to make part payment to the consultants, acknowledging their liability over same. And then 4 or 5, when eventually they made such payments, at a point they took a decision to stop the payment. The consultants instituted an action in court against the Governors Forum. And what happened in court? They submitted to consent judgment. They asked and urged the court to allow them settle out of court. The court granted them an opportunity to settle. They commit terms of settlement to writing. They signed the terms of settlement, agreeing and conceding that such payments be made to the consultant. And then 6, thereafter, the federal government, under the administration of President Muhammadu Buhari, was requested to comply with the judgment and effect payment. The president passed on the request of the governors to the Office of the Attorney General for consideration. I suggested to the president, on the face value of the judgment and the undertones associated with the consultancy services, it was my opinion, the same treatment we meted on P&ID, that let us subject this claim, the consent judgment, to investigation by the agencies of government. Mr. President approved. I directed the EFCC and DSS to look into these claims and report back to the Office of the Attorney General. And these agencies reported and concluded that there is element of there is no element, there are no fraudulent undertones associated with it. The government may continue to sanction the payment. Now, that was the background, and even at that, we took further steps after receiving these reports from the EFCC, among others, to demand for indemnity from the governors, look, as a forum, you incurred this liability. As a forum, you submitted to consent judgment. As a forum, we have subjected these claims to investigation, and we have a report. But even at that, we need independent indemnity from you, establishing that it is with your consent and understanding that this payment should be made in writing. And I am happy to report to you that the governors individually and collectively provided the desired indemnity to the office of the Attorney General, conceding, agreeing, and submitting that the payment should be made. And yes, and that was the basis and the ground on the basis of which we eventually took a decision advising the president that the payment should be made. And then along the line, there was a change of leadership of the Governors Forum. And all the noise making that is now being generated arriving from the Governors Forum is not only unjustified, but indeed a clear case of indeed absence of defense. And one other point of interest you may wish to note is the fact that the new leadership of the Governors Forum instituted an action, fresh action, even when the federal government was indeed acting on the basis of the judgment of the Supreme Court. They now embark on a fresh legal suit, challenging the payment, challenging the previous agreement, challenging the indemnity, and the court dismissed their application. Their case was dismissed by the Federal High Court. So that is the foundation, and I'm happy to report, one, that the judgment in contention was a judgment that was obtained long before the Attorney General Abubakar Malami came into office, long before the administration of President Muhammadu Buhari came into office. It was a product of their own doing, and they have indeed submitted to judicial proceeding. Judgment was entered against them. They have committed to the payment of the money. They have, on their own, indeed effected part payment, and that was the foundation. I close my case, and I wouldn't like to answer any further on this. Now, Mr. Femi of TBC, you raised a question on slow phase of justice as it relates to convictions, and perhaps saying the convictions were yahoo. Well, I have not taken time in all sincerity to profile the convictions, but regardless of the way you want to look at it and the analysis or perhaps the insinuations you want to make therefrom, the bottom line is convictions are convictions, and the successes are recorded, and you cannot dispute the success. But if you feel strongly about profiling of the cases, I think you can please put off a further request, formal, which will in line with the Freedom of Information Act, and I assure you will profile and assist you in taking the trouble of profiling the convictions to identify which stand forward. From Silverbird, you talk of sentences. Well, I have no profile as well, but then there are terrorism cases, and then the conviction, which you rightly know is a function of the judiciary. I will take time, if you make a formal request equally, to profile them accordingly and give you an answer. I don't have the statistics of it. Thank you very much.
They harmonized two questions. Did you harmonize, or you are just raising up your hands? You can't harmonize. Okay, I'll take two more in my capacity, unless the chairman directs otherwise.
I take one more as a chairman.
Arise. And John Bosco. Then, sir, online. There's an Esther Wright who says, Esther Wright, she says it's been a good update, but that there should be the issue of trust between the judiciary and the citizens. If a political office holder is found guilty, such a one should be in jail like any criminal. I don't know. Yes. Then Chooks Ode. It says, Honorable Attorney General, thank you very much. Can you tell us, sir, that your presentation appears like it's all success story. Can you tell us, sir, have you recorded any major challenges as AGF? And two, he's asking for amount that has been recovered and what they have been used for. I guess you mentioned that. I think those are just the two. Yes. And that will be over. Right, sir. Our chairman, he didn't say so. Go ahead, sir.
Oh, okay, they can go ahead.
Good afternoon, Minister of Justice and Attorney General of the Federation. Thank you so much for your submission today. It was an eye-opener. But I would like to ask you, in recent developments, what is the legal position on the ExxonMobil and Seplat issue? And the accusations of some of your staff doctoring the list of those considered for prerogative of mercy. I would like you to react to that. Thank you.
Yeah, Honorable Minister, good afternoon. John Bosco Abubakar is my name. I'll write for Vanguard. Honorable Minister, I want to find out, what's the position of the federal government? What has federal government done in respect of the case that involves the former Deputy Senate President, Ike Ekwuremadu? Any intervention from the federal government to that?
Yes. All right. Thank you very much. By way of addressing the first question on ExxonMobil, the Attorney General, for your information, is not the Minister of State Petroleum or perhaps the Principal Minister on Petroleum. The intervention of the Attorney General can only come in place when I am indeed requested or directed by the President to prefer an opinion over same. And as it stands, no such request comes my way. I'm not in a position to comment one way or the other as it relates to the alleged contentions and dispute relating to ExxonMobil. But then if by any chance such a request is made, I will certainly perhaps maybe consider the possibility of engaging the press over it as it relates to my opinion. No opinion has been formed as it stands now by the Attorney General relating to the dispute. On the issue of the intervention on Senator Ekwuremadu, I have stated in the course of my submission presentation that there has been in existence a mutual legal assistance request and collaboration between Nigeria and other countries across the world. So, to this end, I want to state that we will address request, if there is such request, both on the part of Senator Ekwuremadu. I can remember very well there was a request which was passed through my office, was sealed and meant for delivery to the crime agency in UK at the instance of distinguished senator, which request I was not in a position to comment on because what relates to my office was a simple transmission in view of the fact that the transmission of international documents is a function of a department central authority unit in the office of the Attorney General. And on the request of Senator Ekwuremadu, an agency of government was asked to respond to certain inquiries. They did, and under seal, they presented their report, which was transmitted to UK accordingly. So the implication of what I'm trying to state in essence is we have mutual legal assistance understanding with the UK, and whichever of the agency, either the senator as an accused or suspect, or indeed the agencies in the UK make any request for international support, will respond accordingly. But as far as interest, as it relates to the federal government is concerned, is not a matter over which we can develop any interest. Perhaps maybe if there are interests, there are interests that should be rooted in law. For example, relating to the child in contention, you know, we have Child Rights Act among others, for example. So if there is an allegation of breach, we may possibly consider looking at it from that perspective. In case of consular services, if there is need for Senator Ikeremadu to be accorded one, in view of the fact that he is Nigerian and a request is made, we'll look at it on its merit. So what I'm saying in essence is not about meddlesome interloper, or perhaps maybe just coming into a scene relating to issues that borders on crime. As you are rightly aware, a number of Nigerians were before now convicted across the globe, and then a number of foreigners are equally convicted of recent in Nigeria and over time. So it is about issues that borders on crime. If indeed a crime allegation is an issue, the jurisdiction determines what happens, both in terms of request, in terms of support, and not for a Nigerian government to simply, because you are high-profile personality, jump into the arena. It has never been the tradition of Nigerian government to interfere on anything judicial, local or international, and that stands the position of the government. Thank you. Which one? Which one? Well, the challenges, I have gone far in developing and having in place a book which I intend to publish relating to my experiences. But one major challenge that I think has come up this morning has to do with the Paris Club, because the press is being used to target Attorney General negatively, and you have seen. So I think there are people out there that have greater noise-making capacity in terms of distorting the facts, packaging them, and presenting them to the public. And unfortunately, the investigative journalism that we used to know is no longer what obtains on the ground. So the major challenge, press is part of it, unfortunately.
Thank you very much. Okay. Thank you very much, Attorney General and Minister of Justice, for a most capable, most competent, most elaborate, and most comprehensive presentation we have seen for a long time. I think that if I am asked to give a judgment on this presentation, I will say that it is like that MSc student who has been asked to present a project, and he presented to the department a PhD